Morning, everyone, and welcome back to our weekly webinars. Today is our 91st episode. Over to Anil sir.
Ankit, welcome to all the participants in our weekly webinars, and we are proudly saying that it is 91st webinar of AAA webinar series. So the subject this time is actually very, very important, and there is a big event in this particular subject. So let us first of all understand what is the subject that we are talking about. See, there is a struggle going on between the secured financial creditors. They want to claim the value of their security interest from the resolution plan or from the liquidation. So that is the struggle, whereas the conflicting judgments from NCLT and NCLAT and also the Honorable Supreme Court actually has made this issue a very, very complicated issue. On 3rd of January 2027, Honorable Supreme Court has delivered a judgment by the name of DBS Bank Limited Singapore versus Ruchi Soya Industries Limited and others. I would be repeating the judgment names every time I use a judgment. DBS Bank Limited Singapore versus Ruchi Soya Industries Limited. Judgment delivered on 3rd of January 2024, and today we are sitting on 6th January 2024. So within 3 days, this analysis has been done by us. Judgment is delivered by Honorable Justice Sanjeev Khanna and Honorable Justice SVN Bhatti. Now, this judgment primarily was dealing with an issue that whether Section 30, subsection 2, clause B and subclause Roman small 2 of the Insolvency and Bankruptcy Code as amended in 2019 entitles the dissenting financial creditors to be paid the minimum value of its security interest. This is the main issue, minimum value of the security interest. So for example, a person who actually has a security of 100 and his loan is maybe 200, so he is entitled to 100. In case he enforces his security interest, he will recover 100. Maybe that the loan is 200, even vice versa. In case the total loan is 100 and the security value is 200, so he would recover 200 in case he enforces the security interest, maybe under SURFACE or under Section 52 of the IBC. This particular judgment, now let us try to understand why this judgment came, because in this judgment, ultimately the decision of this judgment was that because of this conflicting judgments from Honorable Supreme Court, so therefore it was decided by this bench that this matter may be referred to a larger bench. However, while dictating the order, they actually had given their view, they have given their opinion that the earlier judgments, more specifically the India Resurgence ARC versus Amit Metallics, India Resurgence ARC versus Amit Metallics, does not seem to be correctly laying the law. Of course, that particular judgment is being used by NCLT and NCLAT because of these disputes. And that particular judgment means Amit Metallics judgment is actually in this particular judgment of DBS Bank Limited Singapore. This has actually kind of loses its importance because this particular matter has now been referred to a larger bench. See, this Amit Metallics Limited, it has been used recently in various judgments by NCLAT, NCLT. Few of the judgments that I can say, like Oriental Bank of Commerce versus Anil Anchalia, the liquidator of Bala Techno Industries, That was the judgment given by NCLAT on 26th of May 2022. And that was also relying on another judgment of the same bench in the case of Indian Bank versus Charu Desai, the erstwhile resolution professional and chairman of monitoring committee of GB Global Limited. These both judgments were in fact relying on Amit Metallics Limited. And then the basic paragraph which was being relied by NCLT and NCLAT, that was the paragraph number 27 of that judgment, which says the judgment of the Honorable Supreme Court in the above case is that when the extent of value received by creditors under Section 53 is given, which is in the same proportion and percentage as provided to other financial creditors, the challenge is to be repelled. So this paragraph is being used everywhere, and the value of security interest of the dissenting creditors as well as those creditors who have relinquished their security interest in favor of the liquidation estate, who have relinquished their security interest in favor of the liquidation estate. So we are not dealing with what exactly is the interpretation of Section 53, subsection 1, whether it will be pari passu or whether it will be having the consideration of priority of charges or value of security interest. This is not the discussion today because that matter is presently pending before the Technology Development Board. However, in these judgments, in these two judgments, especially in the judgment of Oriental Bank of Commerce versus Anil Anchalia, the NCLAT has very clearly mentioned that we thus do not find any merit in the submissions of the learned counsel for the appellant. The submission that earlier judgment of this tribunal in Technology Development Board having been stayed by the Honorable Supreme Court on 29th of June 2021, no reliance can be placed on the said judgment as it loses its importance in view of the subsequent judgment. So since the judgment of Technology Development Board has been stayed, it was stayed by Supreme Court, so the no reliance can be placed on that judgment of Technology Development Board. That means NCLAT presently is not relying on the judgment of Technology Development Board, which says that once the security interest is relinquished in favor of liquidation estate, then there would be distribution which will be pari passu to all the secured creditors based on their total claim and the total claim of the secured financial creditors, proportionate. However, this particular judgment is stayed, so therefore this ratio is not applicable and cannot be relied upon. Now, most of the NCLT and most of the NCLAT benches, they were relying on Amit Metallic's paragraph, which is now a kind of overruled by a bench, but it was a bench of same capacity, so it was now referred to the larger bench. So let us first try to understand what the history of this issue is. Now, the first time this particular matter was discussed in the case of Committee of Creditors of SR Steel India Limited versus Satish Kumar Gupta, and that was discussed on 15th of November 2019. So it was the judgment of 2019, and it was given by Justice R.F. Nariman and Justice Surya Kant and Justice V. Ramasubramanian. So in this judgment, in fact, in this judgment, it started, in case you would see this, Amit Metallics is kind of picking up some paragraphs from this judgment. So in this particular judgment, somehow it was said that the various judgments were also referred, like the Swiss Ribbon Private Limited and others, Union of India, Valal RCK versus Siva Industries was also referred. So it was also said that the COC can decide the manner of distribution of resolution proceeds amongst creditors and others. But Section 30 subsection 2 clause B protects the dissenting financial creditors and operational creditors by ensuring that they are paid a minimum amount that is not lesser than their entitlement upon the liquidation of the corporate debtor. Then the subclause 2 again in fact forfends the dissenting financial creditors from settling for a lower amount payable under the resolution plan. So the financial creditor definitely have a right to dissent if the resolution plan is discriminatory or against the provisions of the law. However, the dissenting financial creditor cannot take advantage of Section 30 subsection 2 clause B subclause 2. That is what the initiation of this particular paragraph from the judgment of Committee of Creditors of SR Steel Limited versus Satish Kumar Gupta. Now, when this judgment, in fact, this continued for some time, and the next judgment, which is the judgment of JP Kensington Boulevard Apartment Welfare Association and others versus NBCC India Limited, that was delivered on 24th of March 2021. This was delivered by Justice A.M. Khanvilkar and Justice Dinesh Maheshwari and Justice Sanjeev Khanna. In this judgment, in the case of JP Kensington judgment, in fact, this paragraph 121.1 of the judgment had that for discharge of obligation mentioned in Section 30 subsection 2B2, because I would be saying that section which is protecting the rights of the dissenting financial creditor, by referring to that section, the dissenting financial creditors are to be paid an amount quantified in terms of the proceeds of assets receivable under Section 52 of the Code, and the amount payable is to be paid in priority over other assenting counterparts. The statute is referring only to the sum of money and not anything else. And in the subsequent paragraph 121.2, the court says, we would hasten to observe that in case of dissenting financial creditor is a secured creditor and a valid security interest is created in his favor and is existing, the entitlement of such a dissenting financial creditor to receive the amount payable could also be satisfied by allowing him to enforce the security interest to the extent of the value receivable by him and in order of priority available to him. Obviously, by enforcing such security interest, the dissenting financial creditor will receive payment to the extent of his entitlement, and that would satisfy the requirement of Section 30 subsection 2B. First of all, let me say that Section 30 is the mandatory contents of the resolution plan. The various subsections of Section 30 provides that the resolution plan must be adherent to Section 30, and that includes payment to operational creditors, payment to dissenting financial creditors, and various other clauses from. And then in case we go to Section 31, it is very clearly said that the adjudicating authority will approve a resolution plan in case Section 30 subsection 2 is complied with, and also Section 30 subsection 4 is complied with. So that means these are the mandatory conditions for approval of a resolution plan. Although in all these cases, the resolution plan was approved, but the interpretation of rights of the dissenting creditors were varied. So in the first judgment that we have seen in the dissenting, in the case of SR Steel India Limited, that we saw that the opinion of the court was that in that process, in case they are getting the value as other secured financial creditors are getting, that actually seems being compliant. Then in the case of JP Kensington, it is said that the value of security interest can be given to the dissenting financial creditor. And in that case also, in fact, that particular land which was mortgaged to a particular dissenting creditor, that was given to that particular dissenting creditor. So this particular judgment was contradicting the SR Steel judgment. Now coming to the India Resurgence ARC Private Limited versus Amit Metallics Limited. This was also given. This was given in May, and in 2 months after the judgment of 2 months after the judgment of JP Kensington, and this was given by Justice. This was given on 13th May 2021, and it was given by Justice Vineet Saran and Justice Dinesh Maheshwari. In this particular judgment of Honorable Supreme Court, in fact, although it was referring to JP Kensington, it was referring to JP Kensington, and it was referring to para 19 of that judgment, saying that these dissenting financial creditors would be receiving the payment of the amount as per his entitlement, and that entitlement could also be satisfied by allowing him to enforce the security interest to the extent the value receivable by him. But the limitation on the extent of the amount receivable by the dissenting financial creditor is innate. Now, then this particular court finally in this Amit Metallics, it is actually said finally that the reasoning given in the earlier portion of paragraph 22 of our respectable opinion is in conflict with the ratio of Committee of Creditors of SR Steel India Limited. So, in this case, Amit Metallics case, the Honorable Court said that the paragraph 22 of JP Kensington is actually in conflict with the Committee of Creditors of SR Steel. So it does not take into account the legal effect of Section 30, subsection 2, the clause B and subclause 2. While it is important to maximize the value of the assets of the corporate debtor and prevent liquidation, the rights of operational creditor or dissenting financial creditors also have to be protected as stipulated in law. Further, the court says in this case, paragraph 17 is respectfully correct in its observation when it refers to the provisions of section 30 subsection 4 and that the voting is essential, a matter which relates to commercial wisdom of the COC. The observation that the dissenting secured creditor cannot suggest that a higher amount be paid to it is also correct. However, this does not affect the rights of dissenting secured creditors to get payment equal to the value of the security interest in terms of the 30 subsection. So this particular judgment finally says India Resurgence ARC Private Limited versus Amit Metallics finally says that the dissenting financial creditors, in case he's getting as other secured creditors are getting, that means it is compliant to the section 30 subsection 2, the clause B and subclause 2. It says very clearly that it becomes compliant. So then in the very subsequent judgment, because see, this judgment was on 13th May, and then another judgment was of 4th May 2023. After 2 years, we actually got another judgment called Vistara ITCL India Limited versus Dinkar Venkata Subramanian, and this was given by again Justice Mukesh Kumar Rasik Bhai Shah and Justice Sanjeev Khanna. In this case also, the Amit Metallics were relied upon. Now, Amit Metallics, in fact, finally, what happened, Amit Metallics is becoming a kind of order of Honorable Supreme Court, which says that the dissenting financial creditors cannot get higher than the other secured financial creditors. So this particular case that we are now discussing, we have discussed the history. Now we are discussing DBS Bank Limited Singapore versus Ruchi Soya, which is a very, very recent judgment of 3rd of January 2024. And it is the judgment where the basic only question of law is whether this dissenting financial creditor should be paid the minimum value of its security interest or not. Now we can actually talk about what are the little Ankit. So in this case, we have now seen the history as SR Steel first, then JP, and then the Amit Metallics. and then finally the Vistra IRCL. So these are the four judgments, and finally this DBS. Am I audible, Ankit?
Very much.
So anything that you would like to add? Now we are discussing the this judgment, and finally how this judgment has said that this is a conflicting issue, although they are of the opinion that the dissenting financial creditor must get the value of security interest. However, how all this, what are the arguments given by the applicant, what are the arguments given by the respondent, that is what we are going to present before our audience. But in the meantime, Ankit, in case you would like to add, or in case you can see there is a question that we can take up.
So Lalit, there's a remark from Lalit Maheshwari ji with respect to the another issue which is pending before the Supreme Court or the NCLAT with respect to the differentiation of security interest with respect to first charge, second charge, and so on. So I think we can share with the audience that that's a separate issue. Right
Yeah.
now, what we're talking about is a different issue because they're like marginally different. First charge, second charge, third charge, and the effect of these charges in the distribution of proceeds in case of liquidation or the rights of the security interest holders is a different issue. But the rights of a dissenting financial creditor from the resolution plan with respect to what value he must receive is a different matter. And yes, I believe that our plain reading of the law, and when I read it, I remember thinking that, oh, there is a protection mechanism for those creditors who do not have a very, very high voting share in the COC, but who have a high value of security with them. But then, yes, these judgments that you have talked about historically seem to be indicating otherwise. That no, that person does not have any right if he has been a wise lender, a wise person who has lent judicially after taking security interest, and he has not lent more than what his security interest is about, then perhaps he will stand to lose in the IBC constituted COC. So that's how it kind of works.
So, Ankit, you are absolutely right. So, that issue, it can be said in two words. One, whether in liquidation proceedings under Section 53 between the secured financial creditors, can the liquidator consider priority of charges, means the first charge, second charge, subservient charge amongst the secured financial creditors, and also the value of security interest of each secured financial creditors. Can liquidator consider this or not? That is the subject which is pending before Honorable Supreme Court, and that appeals have been filed against that order of Technology Development Board versus Anil Goel, that is me. And the first appeal was filed by Kotak Mahindra Bank, although that Kotak Mahindra Bank was not part of that particular judgment. That Kotak Mahindra Bank was not a stakeholder in that case of liquidation of Gujarat Oleo Chem Limited. The Kotak Mahindra Bank filed the appeal before any other party filed, only because this particular order was impacting the new breed of banks. The new breed of banks, they are more collateral security based financing. So in case the examples that normally everyone gives is that suppose a company is already availing some term loans and some working capital, and some in some kind of need, the company goes to another bank, a bank who takes decision based on the collateral security and does the complete due diligence and see that a property of about 100 crore is being mortgaged to me and they are only asking for 50 crores. If that bank takes a decision and after some time the company goes into insolvency, now as per the risk taken by this bank, there was no risk because the security value was almost 200% of the total lending. However, when it goes to insolvency and in case it is said that his entitlement is proportionate to other secured creditors, then it will actually become a losing proposition for him. So that means that all the due diligence is done by this bank, all the best decisions taken by this bank would actually be of no significance once the company goes into insolvency. So this is where the Kotak Mahindra Bank immediately filed an appeal against the Technology Development Board versus Anil Goel, and then subsequently some of the other stakeholders who were the part of this Gujarat Oleochem Limited. So they also went for this appeal, and all the appeals are presently being tagged by Honorable Supreme Court. That matter is pending before the Supreme Court. However, this particular matter is saying that they are not saying that Section 53 talks about this. They are saying that when we talk about Section 53, we also must see Section 52, because the secured financial creditors definition in Section 53 is basically those creditors in subsection 53(1), those who have relinquished the security interest in favor of the liquidation estate under Section 52. So Section 52 is basically part of the code, and it should be used whenever we are interpreting Section 53. Therefore, a dissenting financial creditor in case of liquidation definitely will not relinquish his security interest in favor of the liquidation estate, and he will be able to enforce his security interest. He will be able to recover that money. That would be the liquidation value which is payable to him. That is what is finally in this case of DBS Bank. This is what is the opinion of the Honorable Supreme Court. And this is not showing the interpretation of Section 53 subsection 1, because that matter is pending, and therefore that matter is taking some time. But the dissenting financial creditors, once this judgment of a larger bench will come, for which the ground has already been set in, so that actually will be decided that the dissenting financial creditors should get the value of their security interest. Yes,
So the
Ankit.
question is that can this judgment be used to defend, by a dissenting financial creditor who is aggrieved by the earlier 2-3 judgments, or not yet?
What I believe is that this particular judgment has given an opinion. By just citing these opinions, at least we can say that the decision
should be deferred. The matter should be deferred.
May be deferred till the time the final decision is given by the larger bench. Opinion is given in this particular judgment. However, the earlier judgment and this particular matter, basically, it was with the it was only with the same capacity bench.
Understood. So basically, I think you can proceed, and there are a few questions. There's a hand raised. We can take them after some time, after we've discussed this judgment. I think that will be a good way
So
to.
in this case, Ankit, yes, I think we should do that. In this case, it was the case of Ruchi Soya Industries, and the DBS Bank Limited Singapore was a financial creditor. In fact, a loan of about $50 million was given, and some specific immovable assets and fixed assets of the company was mortgaged to DBS Bank. CIRP started, and a claim of 242 crore was admitted by the RP, and the resolution plan was approved. It was, as you know, Pitanjali Ayurvedic Limited took over this as a SRA with 96.95% voting. This particular resolution plan was approved. However, DBS Bank was a dissenting financial creditor having less than 4% share, approximately maybe less than 3% even. And they objected to the pro rata distribution and challenged the plan's approval before the Honorable NCLT. DBS Bank claimed that DBS Bank is entitled to an exclusive security interest. DBS Bank is entitled to higher value in the distribution pattern. DBS Bank, in case not in the resolution plan, then as a dissenting financial creditor, DBS Bank is entitled to a larger amount, which should be actually equal to the value of its security interest. That is what finally the NCLT, in fact, first of all, the provisional approval of the resolution plan was given, and it was a conditional approval. And then later on, the application of DBS Bank was dismissed by NCLT, and after that, even the NCLAT also dismissed the applications. In fact, the two applications were filed. There is also an issue of when was this amendment made, when this section 30 subsection 2 clause B and subclause 2 was inserted. It was also said in this particular judgment that during that period, this particular DBS Bank was in appeal. And when the DBS Bank was in appeal, this particular amendment was applicable to all those resolution plans which are not approved. So it was also held that if a particular resolution plan was in appeal, that means it has not achieved finality. So this was also the issue. And then in fact, the DBS Bank says that the value of his security interest is much higher and it should be given much higher amount. So the contentions, they actually said that the contentions of DBS Bank was that the pro rata distribution of proceeds does not give regard to the sole, exclusive, and higher value of the security interest. So they're saying, as per the plan, the appellant was receiving 119 crore as against the liquidation value, whereas the admitted claim was 242.96 crores. The appellant, the DBS Bank, in fact, has been deprived of its dues share given its superior security assets. The DBS Bank further said that the pro rata distribution of proceeds overlooks the sole, exclusive, and higher value of the security interest. Therefore, in accordance with section 30 subsection 2, it claims entitlement to 119 crore as against the liquidation value of the secured asset. The amendment, of course, is applicable. Now, the respondents means the Ruchi Soya, what they were justifying the distribution. They were saying that the pro rata distribution approved by the COC, because it is the powers of the COC to approve the distribution. Then the basic argument was that section 30 subsection 2 clause B subclause 2 refers to only section 53 and not to section 52. So this was the basic argument, which was in fact blocked by the Honorable Supreme Court, and the Honorable Supreme Court said that section 52 has to be seen while we see section 53, because the section 52 is giving an entitlement to a creditor to relinquish and or not to relinquish the security interest, and in case the security interest is not relinquished in favor of the liquidation estate, then that financial creditor, that secured financial creditor, will have all the rights to enforce the security interest, recover the value of the security interest, and keep it. So this is where the blocking has been done by the argument that section 52 cannot be used while we are interpreting section 53. Now, the secured creditor's entitlement to distribution is applicable where the secured creditor relinquishes its security interest under section 52, and it is a case of resolution plan. In resolution plan, there is no provision which requires relinquishment or not relinquishing or relinquishing. That is only applicable to liquidation processes. The COC also contended that is not applicable. See, if they do not dispute, because see, even otherwise, once we say that this section 30 subsection 2 clause B subclause 2 has not been complied with, that means the mandatory contents of a resolution plan under section 30 are not complied with. Therefore, the adjudicating authority under section 31 should not have approved this resolution plan. So this section 30 is a mandatory clauses which must be adhered to by every resolution plan. So the conflict in this case, so therefore, like the section, all this was very clearly decided, and finally the decision which is given by Honorable Supreme Court in the case of DBS Bank, Singapore. The court says that the reference to section 53 of the code in section 30 subsection 2 clause B subclause 2 is made with a specific purpose and objective, and accordingly, we have to understand and give cogent and effective meaning to the word and effectuate the intent. Section 53 of the code refers to section 52 thereof. And we cannot isolate section 53 when we refer section 30 subsection 2 and make it meaningless and undo the legislative intent behind the amended provisions, which is clear and apparent. So finally, it also refers to the JP Kensington judgment that the amount has to be paid. The value of the security interest has to be paid. So therefore, the dissenting financial creditor is entitled to a minimum value of monetary terms, minimum value in monetary terms equivalent to the value of security interest. That's what is said in paragraph 40 of the judgment. The creditor's entitlement, and this is clearly when this judgment finally says it says that it is it is the opinion has been given clearly. The opinion is the opinion finally is given. So lastly, this particular judgment says, keeping in the contradictions in the precedents, the bench observed that they are taking a different stand and ratio from India Resurgence ARC Private Limited judgment on interpretation of section 30 subsection 2 clause B subclause 2 of the IBC. However, upon disagreement with the reasoning of the coordinate bench, given in the case of India Resurgence, this matter is being referred to a larger bench. After giving the opinion, they are saying that we observe and we take a different stand. And they are saying that the value of the security interest is to be given. They are saying that section 52 cannot be ignored while we are interpreting section 53. So this is what is this judgment primarily. I feel that this struggle was going on, this fight was going on, this litigation, in fact, a lot of litigations actually came up where the dissenting financial creditors were not getting their rights. So in case this gets resolved, and I think a lot of litigations would also get resolved. So therefore, the judgment of dated 3rd of January 2024 is something which in fact was much wanted. It is good for the credit market of the country. Otherwise, all the new breed of banks, all those banks who actually lend money based on value of the security, they would not have been able to do this business as freely as they were able to. So this is where we have, Ankit, the entire scenario can be
I think also
right.
to add to it, like we see that one of the leading lenders to any company which is under default is normally having that the security in hand. And if that person is under this premise or under this, I would say, uncertainty whether that person will get the value of their security interest through the IBC process, they will never initiate IBC as their first choice. They will first take care of SurfaceE. They will first maybe do other things like maybe having an OTS with that borrower. They will do all other things, but to go to IBC, especially when they know that they would have a smaller share in the entire COC. And that's something that is also very visible in one of the recent cases where I have become an IRP, where one of the major lenders don't have much security, but the smaller percentage voting shareholders in the COC have security interest because the business or the security against which the major lenders had lent money to the company is that security has vanished, and the security is only available with the minority of the lenders. So that process, this judgment will also take care of that process.
So now
We
take up
do
some
have
questions.
a we do have a raised hand. So let me ask Kulshrestha to talk, and if you can unmute yourself and maybe put up your question. While that happens, we can take up is we can.
अब इसमें फिर वही वाली बात आती है कि मैं हम लोग मेहनत करके चलो नंबर निकाल भी लें बट वो जब मन से रेडी नहीं है वही वाला सीन हो जाता है तो हम टाइम वेस्ट क्यों करें
So I think what we can do is we can
Take some
the
of the questions.
the question that I see is that the value of security means the fair value or the liquidation value. That's the question. It has come in that what is the
The
value of
value of security means in this case is the liquidation value that is very clearly mentioned in section 53. And it also it's very clearly mentioned. It is very clearly mentioned in section the section 30 subsection 2 clause B and sub clause 2. It is very clearly mentioned. It will be liquidation value, not fair value.
Then I'm allowing Mr. Sevarama Prasad Bhamidi to talk.
Good morning, sir. Thank you for this talk. So it's not a question. My request to you is, can this be continued in the next episode also, taking into consideration with examples of some numerical, I mean, whatever the case studies, that numerical examples, even though in the abstract manner I have understood the concept, I think it would be more emphatic if you the same from the case the numerical figure is also mentioned and explained, sir.
So we can take up some of the numerical examples with you offline. As
Yes,
we
sir.
have said very clearly, we have given two illustrations. One, that in case the value of the security is 100 and the total loan is 50, then the dissenting creditor should get total 50. And in case the value of the security is 50 and the loan is 100, then also he will be able to get the liquidation value of the security interest, that is 50. So these illustrations we had given in our talk today, and I believe as far as these other numerical examples are concerned, those would be having the same ratio.
So in the cases I mean referred to you, that means that COC has approved a resolution plan where the amount and where the amount distributed to the dissenting is coming less than 50 crores.
Yes, the case where the DBS Bank Singapore case, which is decided by Honorable Supreme Court, in that case, the total loan was $50 million and their claim was 236 crores. However, they were given, the value of their security was much higher. They were given proportionate as it was given to the other secured financial creditors. The value of the security interest of DBS Bank was not considered while even allocating the amount to a dissenting financial creditors. So that is the real case in this. And the DBS Bank wanted that my entitlement is equal to the value of my security interest, equal to the value of all those fixed assets, all those shares which are pledged to me. So that should be given to me. So that is the real thing that the Supreme Court has attended to, and the Supreme Court has given an opinion that he is entitled to the value of his security interest, but the matter has been referred to a larger bank because they are kind of giving a different opinion against a coordinate bench.
Okay, sir.
Then I have a question from Mr. Pankaj Tabriwal. He's saying basically the lower of liquidation value of security interest or the admitted claim of the secured creditors shall be paid. This is his query. So I think admitted claim has no role here.
No, I think
Yeah, you're right. Yeah, lower of the two.
lower of the
Yes,
two.
exactly. That's
Exactly.
accurate.
The
Then
lower of the two should be given.
yes. Then we have a question that in case of home buyers are dissenting, whether they would be considered as secured or unsecured. So we
The
had talked about
NCLAT, there is a Supreme Court judgment which says that if one or few home buyers are dissenting, that does not mean they would not be considered as dissenting because they belong to a class of creditor. So then the entire class of creditor would be considered as voting in favor of the resolution plan. So the class of creditors are moving collectively. In case 50% and more people who voted, if they vote positively on the resolution plan, then none of the others will be considered as dissenting. That has been a judgment from Honorable Supreme Court. So the class of creditors, on class of creditors, the concept of dissenting is
So
not.
I think the question has been revised. Now the question is that if the entire class is dissenting, then what will happen? So there again, the present position I believe is that they're considered unsecured, but there is a debate on that status as well, whether the Transfer of Property Act provides them with a secured status.
Yes, in case the entire class, in fact, would dissent, then they would be considered as unsecured financial creditors as of now. So, as the law stands today, the dissenting of the entire class of home buyers would not help them anyways.
Then we have a question that there's a remark rather that the judgment of DBS Bank is interesting, and now the lenders will be in dilemma whether to consider adequate security interest or have the consequence of IBC code in background while lending to corporates. I think it's resolving this dilemma. The dilemma is already there.
It was there, but then this judgment,
This judgment
after the
is, yeah,
after the
this
larger
judgment will
bench,
resolve it.
yeah, it will be resolved.
It will be resolved once it is taken care of by the larger bench. So then we have a question that resolution plan provides for relaxing personal guarantee of PRA who are promoters of MSME CD. Resolution plan is approved by a requisite majority but not voted in favor by FC who has filed for personal insolvency of the PG to CD. Whether dissenting financial creditor is entitled to enforce PG and demand its share in liquidation value of the CD. So I think during the CRP process, in case you involve basically the resolution plan is providing for personal guarantees of PRA, we have a few judgments which kind of I think this is Unibera. Unibera was a judgment that we referred to. I think it was Unibera where we talked about how the personal guarantees can be part of a resolution plan, and there this was upheld that yes, the personal guarantees and the treatment of personal guarantees can be part of the resolution plan. So here the dissenting creditor, whether he can pursue the personal insolvency, that's a question that needs to be still tested in the judiciary.
So I
Then
think it's like, yes, we can take the question in case there.
So then we have a raised hand. I will just allow, it says MSV 8200. If you can please unmute and share your question. I'm also allowing Mr. Kisle Kanu.
So this is Vishwanathan, Mathur Sabha Vishwanathan, Northi, from Chennai.
Yes,
So
please.
my thing is, during the CIRP process, if a resolution plan is been voted and the dissenting creditor has not been voted in favor of the resolution plan and got dissented. In this case, what exactly happened? The liquidation value is the plan value is lesser than the liquidation value, and the dissenting creditors are asking the equivalent amount of the liquidation value. Is it correct?
Yes, I think the so far when we were talking about Amit Metallics Limited, in that case, it was suggested that the dissenting financial creditors will also get the similar amount as the other counterparts are getting. So in case the resolution plan is for a value which is lower than the liquidation value, so the liquidation value which is again payable to the other counterparts. That is what is the entitlement. However, with this judgment of DBS, where the opinion is changing, so in this regard, the value of the security interest of that dissenting financial creditors will be considered. And he can always challenge that the value of my security interest is much higher. So that he can always challenge. So therefore, it is not really impacting the basic application of law, even if the resolution plan is offering lesser than the liquidation value of the corporate debt. The concept remains the same.
Say the resolution applicant may not be knowing what is the liquidation value. In this case, whether he has to shell out more money.
No, the distribution will change because the distribution, whatever is the amount which is being offered in a resolution plan, how the same will be distributed, that is the prerogative of the first, it is the prerogative of the RA, and then it is the prerogative of the COC. There can be some conditions which can be some conditions of distribution which must be accepted by COC if it is insisted by RA. However, the total amount which is being offered to financial creditors, how the same would be distributed to the financial creditors, that is the prerogative of the COC and not of the RA.
Actually, the resolution applicant has, in a fair and equitable manner, as per the code, he has given individually to everyone. So in such case,
that can be changed. That can be changed by the committee of creditors.
So that for which whether the PRA has to accept or
that PRA will accept in that with regard to the amounts allocated to the financial creditors, not as far as the amounts which is being offered to the operational creditors, statutory authorities. That of course, whatever RA will do, that has to be done. However, in case any distribution, any offer is not compliant to Section 30, that of course will make the resolution plan as not legally compliant. So the distribution of the amount which is being offered to financial creditors amongst different financial creditors, this is the prerogative of COC, and the RA will accept it.
My thing is, numerically, I'm saying, suppose the plan value is 50 rupees.
Yes.
The liquidation value is 100 rupees.
Right.
The dissenting value, the dissenting creditor is getting only 10 rupees. Whereas in the liquidation value, the stake home, that is the security interest is 15 rupees. But if the rest of the other financial creditor are accepting, and if you want to change, then other people also will get dissented, no?
You see, like it is the, in case the resolution plan is not acceptable to all, if it is not lawful, then let it be not accepted by everyone. Because once, see, it is the duty of the RP to see whether the resolution plan is compliant to law or not. If the resolution plan is not offering liquidation value to dissenting financial creditors, then the resolution plan is not legally compliant. So it cannot be approved by the adjudicating authority. Maybe the other creditors are agreeing to that, but the dissenting financial creditors definitely has a separate rights under the law. He should be getting the liquidation value of the security interest.
Thank you.
We can now take up the question from Mr. Kislekanu.
Hi, sir. Good afternoon. Hope I'm audible to you all, sir.
Yes, yes.
Sir, my question is, I had a matter in which the company has gone with a CRP, and we have been declared as a financial creditors. But somehow when
we are not able to hear you.
We are not able to hear you.
Will be declared as a sub. Am I audible, sir?
No.
Yeah.
Hello.
You can repeat.
Sir, my question is this: there is one case in which we have been declared as financial creditors
I think
in
there's
CRP.
a network issue, so we're not able to. Your voice gets
You
cracked.
can write your question.
You can write your question. You can write your question. There's a problem with
Am
the
I audible,
network.
sir?
No,
You
I
can
don't
write.
think it's
You can
possible.
write. You can write your
You can write
question.
your
We'll
question.
take it up.
Your voice is breaking.
So we have a few interesting questions that if the plan is below the liquidation value, how will the distribution happen? If the total plan itself is below the liquidation value, which is required to be distributed to the dissenting financial creditor, then the plan will fail. That's what I
Certainly.
understand.
That's what we
Yes, that's
just
what we
answered
just
that.
talked about. The second question is that in case of secured creditor has a case loan for the car and the value of the car is negligible, and another secured creditor has a loan against security, say land with higher value, whether both secured creditors will be considered at par. With respect to the resolution plan, that's what we were talking about, that if any of these two creditors have the right to dissent, then the secured creditor who has the right over the land will dissent and get the value of that security interest in case he is not given the value of the land as part of the resolution plan, and he cannot then stand to lose against the other creditor who only has the security against the car. That's what we're talking about. In the present scenario, in case the person who has that loan against the car or security of the car, if he has 70% COC voting share, he can pass a resolution which has a pari passu, which has a distribution at par, which is what is being debated here. Then we have a yeah.
Yes.
Then we have a question that from Milan Rastogi ji is asking that in case resolution plan value is more than liquidation value, which value is to be received by the dissenting creditor? If the resolution plan value is more than the liquidation value, then the resolution plan is compliant with the requirement for the resolution for the dissenting creditor to get at least the liquidation value. So the
No, I
plan
think
will
what,
pass.
no, Ankit, we presently, what this DBS Bank judgment is trying to say, how the liquidation value of the dissenting creditor will be calculated.
Hmm.
Liquidation value in any case is the law, and every judgment is talking about the liquidation value to be paid to the dissenting financial creditor. This judgment is saying that the value of the security interest of the dissenting financial creditor should be paid. So the liquidation value of the dissenting financial creditor would be the value of the security interest of the dissenting financial creditor. This is the basic difference. Liquidation value would be the value of the security interest of the creditor. Yes, Ankit.
I think we've taken care of majority of these questions. Gisle ji was trying to ask the questions. Question is talking about a subservient charge holder. He's saying that the financial creditor, where he's a subservient charge holder, will he be entitled to a token amount rather than the proportionate share in the resolution plan? So for a subsequent charge holder, again the question is what will be the value that will be allocable to this creditor if
I think
liquidation happens?
yes, subservient charge. So let us first of all understand the priority of charges. So the priority of charges is referring to that any one particular lender can have the first charge on that asset, another lender will have the second charge, another lender can have the third charge. So anything like a subservient means junior charge. So once the first charge holder is fully settled, and if there is still an amount left in that security interest, that will go to the second charge holder. And once the second charge holder is fully satisfied, then the amount will go to the subsequent subservient charge holders. So this is what is the priority of charges. So any lender having subservient charge, it all will depend upon the value of the security interest and the total claim from the first charge holder. Then the value of the security interest of the second charge holder or subservient charge holder will be arrived at. Yes, once there is a value of the security interest after settling the first charge holders or second charge holders or any superior charge holders, that will be the value of that will be the liquidation value due to that dissenting creditor. Now, as far as this, what they would be offered, that of course is pending before Supreme Court, because the Supreme Court is presently sitting on that issue, whether the priority of charges and the value of security interest would be considered by the liquidator while distributing the proceeds to secured financial credit. That matter is pending.
All right, so I think we have taken care of most questions. We are we reached the time and the deadline. Maybe the other questions that are still pending or the comments that are still pending can be taken offline. We have a raised hand as well from Mr. Rajesh Surup. So request unanswered questions, if any, to be taken up offline. You can always ping me or Anil sir and we'll take it up.
Thank you very much.
Thank you, everyone. Thank you.
And there is no other objective, and this is our way of learning as usual. Thank you.
Thank you. Thank you, everyone.